Former President Donald Trump's legal team is petitioning the U.S. Supreme Court to keep him on the ballot in Colorado. The move comes 1 month after the state's Supreme Court narrowly found Trump violated the so-called insurrection clause of the 14th Amendment on January 6, 2021. In a new legal filing Thursday, Trump's attorneys argue the former president, quote, did not engage in anything that qualifies as insurrection. Oral arguments at the Supreme Court are set for next month. James Trusty joins us now. He's a member at IFRA Law and a former attorney for Donald Trump. Jim, where does the Supreme Court land on this ballot issue?
That's a great question. Well, my personal belief is that the trial itself, this idea of putting on evidence in a very relaxed kind of setting for evidentiary rules, that's really a due process issue, but I don't think they'll reach that. For the sake of consensus, I suspect Justice Roberts is going to look very hard at the foundational issues that accompany this procedure. And that means things like whether or not the president is even covered by Article 3 of the 14th Amendment. There was a real interesting ruling from the district court, the lower court in Colorado, that said, I think he has been guilty of insurrection, but I also don't think that this section even applies to him under the legislative history going back to the 1700s. So I suspect the Supreme Court with Roberts, if he wants to get up to something like a 7-2 or 8-1 or 9-0, may well land on something to do with whether it's a federal question, whether the order applies at all, and not really get to the merits of the trial as much as saying that procedurally we can't have these kind of mini trials in 50 different states.
We're also expecting a decision by the appellate court here in Washington on presidential immunity. Which way do you think that goes?
I think probably poorly for President Trump. I was in the courthouse that day. I didn't get into that particular room. I did talk to some friends that had been in there, and they said it was a pretty hot bench for President Trump's lawyers, and that feels familiar from practicing in D.C. But I can tell you that, the idea of blanket immunity is one that I think is going to be hard for the D.C. court to swallow, may be hard for the Supreme Court to swallow. They could come up with a carve-out eventually at a Supreme Court level, which essentially tracks executive privilege, saying if you're doing your core responsibilities, we're going to give you protection. But you can't just run out and kill a political opponent and expect to have immunity. So there may be a little more of a nuanced approach than just a thumbs up or thumbs down. I think it'll go poorly in D.C., but I'm not sure about the Supreme Court part. It'll be very interesting.
Yeah, so let's turn to the Georgia racketeering case. The judge has set a hearing for February 15th on allegations that the district attorney, Fani Willis, hired a romantic partner as one of the lead prosecutors. Does this issue put the larger case in jeopardy?
Yeah, it does, but not for the reason you might think. Everyone's focusing on the relationship and Carnival cruises to the Caribbean and some of the things that are pretty tawdry and pretty embarrassing for Fani Willis, as well as the fact that the person she selected for special counsel apparently has never even tried a felony case. So there's a lot there that's kind of on the TMZ track, the sensational track. But underneath it all, there's a real core issue that's interesting, which is that Fani Willis, who knew this process, was supposed to go to the Fulton County Board of Commissioners to obtain permission and funding for special counsel. She didn't do that. She also didn't have Mr. Wade file an oath of office like any other district attorney or assistant district attorney would do in that position. So the argument is not directly about the relationship, although there are some ethical issues there and some concerns about conflict of interest. It's that he was invalid, that he was never appointed officially, or at least acknowledged as an official special prosecutor. He shouldn't have been in front of the grand jury, shouldn't have been able to question witnesses, shouldn't have been able to get an indictment. So it's a motion to disqualify, but it's also a motion to dismiss the indictment because he essentially had no authority to present the case.
So can the case be revived if there's some technical issue?
Well, legally and practically might be different here. Legally, if there was a disqualification of Fani Willis and Nathan Wade, and if the indictment was dismissed, a new prosecutor from another office could theoretically come in and revive that thing. Practically, I can't imagine DeKalb County or Cobb County prosecutors are going to pick up and run with something this snake bit, this difficult, this high profile. So practically, I think the answer is if the case got dismissed, that it would in fact be dead.
And just finally, on the Hunter Biden federal prosecutions, his legal team filed a motion to dismiss this week, in recent weeks, on the basis that this Delaware felony gun case violates the Constitution. They're also arguing a vindictive and selective prosecution. What does that tell you about the strength of their defense?
Well, not a whole lot. I mean, look, if you file some of these preliminary motions, sometimes the attorneys think they have a real good chance, sometimes they don't. I don't think the selective prosecution is anything but ironic here. I mean, the Biden family, as laid out by Comer's committee, might have a lot to answer for, and not just a small tax case and a small gun case. So I don't think that the broader constitutional challenge on him being, subject to an equal protection violation is going to fly. The gun count is actually a little bit interesting. It's a rarely used statute compared to a felon in possession of a firearm. It's rarely used, but there's cases that have come down since a Supreme Court ruling about 2 years ago that have said that, this is not what our founding fathers anticipated in terms of disqualifying people from firearms. So Fifth Circuit, Third Circuit cases are bouncing around, invalidating the same statute or the same collection of statutes that Hunter Biden is charged under. And so the Supreme Court may get to that that Fifth Circuit case sooner rather than later, and that will basically decide Hunter Biden's case. So there is some teeth to that. We'll see where it goes. The Department of Justice responded with about a 40-page history lesson going back to the 1300s, but I'm not sure that's not a sign of weakness. So we'll see if the Supreme Court weighs in on the notion of drug abusers and firearms and whether they'll keep it as a statutory violation under the federal code.
Yeah, certainly a lot there. Jim Trusty, thank you for your analysis.